My name is Etti Edu, and I'm managing partner of Jackson, Etti Edu. And I think the question everybody always asks me is, what's your job as a managing partner? And I tell them my job is a very easy job, and I'll tell you why. I'm responsible for looking after our clients, our people, and the firm's strategy. So our clients come first, as you can see in the order I've put it. You come first. You're the most important people to us. And when I say looking after our clients, we've even broken it down further. So we're very specific as to what that means. So the first thing is legal expertise. That's why you come to us, for legal expertise. The second one, which we do, and we hope you notice, is operational excellence. And the third one is what we call smart collaboration. The third one is very important because we make sure all parts of this firm work together to deliver value to our clients. So as I said at the beginning, that's the most important thing to us as you come first. It's all about client satisfaction. Second thing is people, right? First of all, we have 14 partners, 7 female and 7 male. We're the most diverse law firm in terms of our partners from a gender perspective in Nigeria. So it's something I think I should boast about. We normally don't like to boast in JE, but that I would boast about. Apart from that, we have a wonderful team of people. And those people are our paralegals, our business support, plus our over 60 lawyers. That team makes up what we call JE. So our people are the most important thing to us. And to be honest with you, we think it differentiates us from everybody else because we invest heavily in our people. But again, it's for you to tell us if we're better than everybody else. The next thing that's important is we have a sector approach which differentiates us, again, from our competitors in Nigeria. We've had a sector strategy for over 5 years, and we're built around 5 key sectors: financial services, technology, media, and entertainment; FMCG, as we call it in Nigeria, which is fast-moving consumable goods; energy and infrastructure; health and pharma. And this sets us apart from everybody else. Every member of this firm, from what we call second year post-call upwards, including the partners, are members of these sectors. By having this sector knowledge, it differentiates us from the rest of the pack. We have a Pan-African approach. We have contacts throughout Africa, and we have associate offices in Cameroon, Ghana, and Zimbabwe. So we're able to meet your needs on the African continent. We think that's key in delivering value-added service in today's new world. The third thing, as I said, is the buzzword: strategy, strategy, strategy. I can't reveal our whole strategy here, but I can tell you things that we're doing that are new. So we've just set up a specific department for our regulatory compliance and governance. It's the new baby. And it's in addition to our older departments, established departments: intellectual property, litigation and dispute resolution, and the corporate commercial department. This fourth department was birthed, and we think it's part of this new world. It's all about regulatory, compliance, and governance. You can find it on our website. Having said that, I think I've captured the key elements of JE, which is around our clients, our people, and our strategy. Thank you very much.
Good morning, everyone. Distinguished guests, colleagues, and friends. My name is Ed David Kolawole, and I have the pleasure of moderating today's webinar titled Navigating Termination and Dismissal, Avoiding Legal Pitfalls in Nigeria. On behalf of Jackson, Etti Edu as a firm, I welcome you all to this webinar, which I believe will provide clarity on some of the most sensitive and complex aspects of employment law, ranging from lawful termination procedures, redundancy and retrenchment, dealing with wrongful dismissal claims, to contract variation in the terms of the terms of employment. For records, today's session is scheduled for 2 hours. We would have a keynote address from the keynote speaker, which will then be followed by a panel discussion. Participants are encouraged to use the Q&A chat box for questions, which will be addressed during the Q&A segment. Please also feel free to put in your questions as the speakers speak, so a mental note is made. This session is being recorded, and once again, I welcome everybody to this session. Next on our agenda is the opening remark, which is going to be delivered by one of our leading partners in the law firm of Jackson, Etti Edu. He's a seasoned litigator with experience in acting on behalf of industry leaders across diverse sectors in employment matters at the National Industrial Court. Without further ado, please let me welcome Mr. Obafemi Agaba to deliver the opening remark. Thank you.
Thank you very much, David. Good morning, ladies and gentlemen, and it is my pleasure to welcome you all to today's webinar on the theme, Navigating Termination and Dismissal, Avoiding Legal Pitfalls in Nigeria. As David said, my name is Obafemi Agaba, and I'm the partner that leads the dispute resolution practice at Jackson Etti Edu, where labor and employment dispute is at the forefront of what we do. Over the years, we all cannot overemphasize the importance of understanding HR-related issues and how to navigate any disputes arising from this. A number of questions always come up for us to answer. How do you distinguish between a lawful termination and a wrongful termination or unfair dismissal? Can an employee be terminated during an ongoing disciplinary process, or even if there is any criminal allegation against an employee, can he be terminated whilst that investigation is ongoing? What are the risks around termination where you have not put in proper processes in place, or you are in a hurry to terminate somebody's employment because you feel is a continued risk to the organization? How do you do that in a hurry without risking litigation? A whole lot of things are abound, and that is why we have put together a seasoned panel to come and discuss the different issues and educate us and guide us as HR practitioners as well in how to do these things without much ado. Be that as it may, we know that even when you have taken every step you need to take, you have taken all the due procedure, it does not really stop litigation. So what are we trying to achieve this morning? One is for us to, first of all, ensure we do things properly to minimize the risk of litigation. And even after we have done all of that properly, we have followed due process and litigation still comes, is for us to be able to defend such litigation effectively in the best interest of the organization. And without much ado, I welcome you all once again, and I look forward to a very interesting deliberation. And on that note, I hand over back to Ed David. Thank you very much for joining us this morning.
Thank you so much, Mr. Agaba. Just even from that opening remark, we can tell we are in for a great session today. Thank you once again. Next on our agenda would be the speaker introductions, and I can confirm that we have an exceptional panel here today, which we are honored to have. Today's session brings together experts, both from the legal profession and the corporate practice, to share their experiences and provide practical solutions to these sensitive issues. We also have a distinguished member of the bench on this panel. And like I said earlier, our goal is that everyone leaves here better informed with a clear understanding of how to approach employment exits properly in line with legal standards. Without wasting too much time, I would introduce our first speaker for today, who is the keynote speaker. I introduce Honorable Justice I.J. Essien, PhD of the National Industrial Court, sitting in the Lagos Judicial Division. Please help me welcome Honorable Justice I.J. Essien, PhD. Thank you. Our next speaker is Mr. Taiwo Adeshino, a partner in Jackson Etti Edu. I would say that few people understand the balance between business realities and legal compliance quite like Mr. Taiwo Adeshino. I can confirm that Mr. Adeshino is a legal practitioner. Legal practitioners who understand the business of law. Like Mr. Adeshino heads the corporate and commercial department of the firm. He is also the sector head of the firm's energy and infrastructure sector. He routinely acts for governments, institutions, financial institutions, among others. I can also say that Mr. Adeshino leads the firm's labor and employment advisory team, where he provides strategic counsel on a wide range of employment-related matters, including employee engagement, termination, industrial relations, trade union disputes, workplace investigations, and regulatory compliance. Please help us welcome Mr. Taiwo Adesina. You are welcome, Mr. Taiwo Adesina. Thank you.
Thank you very much for
Our
having me.
next speaker.
It's a pleasure.
Thank you, sir. Our next speaker is Mr. Gbenga Bello. Mr. Gbenga Bello is currently an associate director in IHS Nigeria Limited. He's a legal practitioner that has had his stint with the Nigerian Stock Exchange, managing the entire disciplinary of the process of the exchange, making sure this process is robust and in accordance with international acceptable standards. Mr. Bello has dedicated himself across diverse areas of practice, 25 years, which has cut across trial and advocacy, commercial and regulatory advisory, and strategic thinking for in-house practice. Specifically, Mr. Bello was part of a team that advised financing of $180 million senior crude oil pre-export financing facility to a Nigerian oil major, as well as advising and securitizing a further $300 million United States dollars senior crude oil pre-export financing facility by the same bank. Mr. Bello holds the honor of arguing the first case where the National Industrial Court decided that a training bond was enforceable in Nigeria, showcasing his expertise on matters revolving around employment and labor law. Please help me welcome to the panel, Mr. Gbenga Bello.
Thank you very much. I'm glad to be here.
Thank you, Mr. Gbenga Bello. Our next speaker who I'll be introducing is Mrs. Ngozi Uzom. Ms. Ngozi Uzom is a seasoned practitioner who specializes in employment law, immigration law, employee relations, and alternative dispute resolution. She holds a Master's of Law in General Law from Nasarawa State University and a master's degree in industrial and employee relations from the University of Turin in Italy. Mrs. Uzom is a notary public, an active member of the Nigerian Bar Association. He's also a member of the Commonwealth Lawyers Association, the Chartered Institute of Arbitrators, the Chartered Institute of Personnel Development, and the Society for Human Resource Management. I can confirm that Mrs. Uzom combines legal expertise with human resource knowledge to promote lawful, fair, and effective employment practices across Nigeria. Please help me welcome Mrs. Uzom to this panel.
Thank you.
Thank you, Mrs. Uzom. And finally, but not last, we have our own Mark Williams Nwog, who is on the panel. Mark Williams is a senior associate in the law firm of Jackson, Etti Edu, where he routinely advises and represents clients across diverse sectors on matters revolving around employment. Today, you'll be sharing exactly what to do and what to avoid when employment terms need to be varied or reviewed. Please help me welcome to this panel, Mr. Mark Williams Nwog.
I'm honored. Thank you so much.
I appreciate all the attendees for the webinar. We don't take it for granted that you are in this session. We appreciate your attendance, and we hope this proves to be a knowledgeable point and where we can all take away information that would help us in navigating matters revolving around employment. The next on the agenda will be receiving the keynote address from our keynote speaker. We all know that when it comes to employment disputes in Nigeria, the final word comes from the National Industrial Court. And today, we are very, very fortunate to hear from the bench itself. Please join me as we welcome Honorable Justice I.J. Essien, PhD, to deliver today's keynote address. Your Lordship, you have the floor.
Good morning, gentlemen.
Good morning, Your Lordship.
Good morning. Good morning, my lord. Good morning, my lord.
All right. First, I must thank you for inviting me to speak on this webinar. I'm delighted because of all the judges in my court, you chose me. I don't know why you did that, but all works for good. Without wasting time, I'm supposed to speak on managing termination, dismissal, and redundancy, avoiding the legal pitfalls. Before I go on, I want to say that I recall that Honorable Justice Holmes of the Reale School of Jurisprudence had advocated that law is the prophecies of what the court would say and nothing more pretentious. This assertion readily finds relevance today in our case law, as the court has laid down principles which today regulate the ever-recurring litigation on the subject of termination and dismissal. These principles have, to a great extent, complemented the extant statutory provisions on the subject. It is important to mention that before the Third Arbitration Act, jurisdiction over labor dispute was vested in the High Court and also in the Federal High Court. However, after the Third Arbitration Act, Section 245C1 has now vested jurisdiction in labor matters in the National Industrial Court. To this extent, this court has jurisdiction in civil causes and matters relating to or connected with any labor, employment, trade unions, industrial relations, and matters arising from workplace, the condition of service, including health, safety, welfare of labor, employee, worker, and matters incidental thereto or connected therewith. Further to this, Section 245C2 provides that notwithstanding anything to the contrary, in the Constitution, the National Industrial Court shall have jurisdiction and powers to deal with any matter connected with, pertaining to, the application of international convention, treaties, or protocols of which Nigeria has ratified relating to labor, employment, workplace, industrial relations, or matters connected therewith. The implication of this section is that all international treaties and conventions which Nigeria is the signatory do not need to go through the requirement of Section 12 of the Constitution for it to be ratified by the National Assembly before the National Industrial Court can implement it. The court is the only court that can apply treaties directly once it is ratified. With the Third Arbitration Act, the National Industrial Court, as a specialized court, is now positioned to develop labor jurisprudence, and which impact has been felt in its post-Third Arbitration jurisdictional decisions. Well, let us go into the nitty-gritty of the issues, the terminal issues that we have to discuss with. First, we'll look at what termination of employment is. Employment contract is a relationship between the employer and the employee, which is regulated by law and the agreement between the parties. This relationship is not expected to last forever. There are several ways in which an employment contract can be terminated or brought to an end. I will just list a few of those means. One, either party to a contract of employment may terminate the contract on the expiration of notice given by him to the other party. This requirement of notice is stated in Section 11 of the Labor Act. Two, where a contract of employment is for a fixed term, that contract automatically comes to an end at the expiration of such terms, except it is renewed. Three, a contract of employment may be terminated upon the dismissal of the employee for misconduct. 4, a contract of employment may come to an end upon the declaration of redundancy and retrenchment of employees. 5, a contract of employment may be terminated upon the retirement or resignation of the employee. These are several rules. There are several rules under the statutes and case law to manage these incidences when it occurs. It is a failure to abide by the rules and the terms of the contract of employment as relates to termination that often results in litigation. Now, we are going to look at the termination of employment, or the act of ending the employment, in the 3 thematic issues we have to discuss here. First, termination of master servants' employment. This kind of employment is sometimes referred to as private employment as opposed to public employment. The rules of termination here was largely developed by the common law which we inherited. The rule has always been that a master is at liberty to terminate the services of a servant for good reasons, or for bad reason, or for no reason at all, provided that the termination is done in accordance with the terms of employment. This position of the law has always been affirmed and in a plethora of cases. For instance, in Ajayi and Taxigo, citation supplied, the court went forth to state that in ordinary case of master servant, as in the instant appeal, the master can terminate the contract with his servant at any time for good or for bad reasons or for none at all. The motive for exercising a right to terminate the contract of service of a servant does not render a valid exercise of that right ineffective. However, even where the termination breaches the terms of the employment, the termination, though wrongful, cannot be declared null and void because of the understanding that a willing employee cannot be forced on an unwilling employer. This has been decided in the case of Ikemba and Pyramids Company Nigeria Limited. Like I said, labor jurisprudence is still evolving and developing. Now, this common law position is gradually being phased away when you have regards to case law and also to international conventions. Now, the rule now is that where the master states a reason for termination, the duty is on him to justify the reason. Where the servant complains against the reason for termination, this is enforced by ILO Convention 158 of 1982 that deals with termination of employment. The convention is called the Termination of Employment Convention 158 of 1982. Now, like I said earlier, the court is under a constitutional duty to implement international conventions as it relates to labor. Therefore, if you look at section 254C2 of the Constitution and Article 4 of the Convention provides the employment of a worker shall not be terminated unless there is a valid reason for such termination connected with the capacity or conduct of the worker or based on the operational requirement of the undertaking, establishment, or service. Further to this, Article 9 sub 2A provides that in order for the worker not to have to bear alone the burden of proving that the termination was not justified, the method of implementation referred to in Article 1 of this convention shall provide for one or the other or both of the following possibilities. A, the burden of proving the existence of a valid reason for the termination as defined in Article 4 of this convention shall rest on the employer. Therefore, the jurisprudence, which is an aspect of the best international practice, is that it is no longer the law that an employer can terminate an employment at any time for good or for bad reason or for no reason at all. The law now is that the employer must give a reason for the termination and go on to justify the reason for the termination to be valid. If you see cases like Union Bank of Nigeria PLC against Haruna, the court made it very clear. Say the cardinal principle of law is that an employer is not bound to state any reason why an employee appointment is being terminated. However, it has also affirmatively been held and laid down that where a reason is stated by the employer as to why the appointment of an employee is being terminated, the burden of proving or establishing that reason will squarely be on the employer or the master. This was also the reasoning of the court in Fakwade against Obafemi Agaba University Teaching Hospital. The settled position of law is that while an order of reinstatement is not normally ordered by the court where it is discovered that the termination was wrongful, the court has always awarded damages. This was decided in Olaniye and others against University of Lagos. Now, this practice is affirmed by Article 10 of the Termination of Employment Convention number 158 of 1982. That article provides that if the bodies referred to in Article 8 of this convention finds that termination is unjustified, and if they are not empowered or do not find it practicable in accordance with the national law and practice to declare the termination invalid and or order or propose reinstatement of the worker, they shall be empowered to order payment of adequate compensation or such other release as may be deemed appropriate. Therefore, it is very clear our national law does not allow for us to make an order for reinstatement in a private contract of employment. But that does not also stop us from awarding damages where that termination breaches the contract of employment or it breaches any statute. Now, before, it used to be, the rule used to be that the damages awardable is the remuneration which the employee would have earned during the period of notice. But that has changed. NIC has changed that position. Now we have given wide powers to award damages beyond what is claimable for the notice period. We have awarded in NIC damages that run to like 2 years' salary for the breach of the contract. So it depends on the circumstances of the case. We can award as much as 1 million and even more, depending on the circumstances of the case. Now let us look at termination of public employment. Public employment, otherwise called employment with statutory favor, is the employment which the employee enjoys a secured working tenure. In other words, the employee is supposed to continue in the employment until retirement. The employee here are civil servants or public servants within the meaning ascribed to the public service of the Federation of the State by Section 318 of the 1999 Constitution. Also, the employees may be employees of entities created by statute, like the university and other statutory bodies. Because of the underlying feature of security of tenure, this kind of employment often terminates at the retirement of the employee. Outside this, the employees here oftentimes are dismissed for gross misconduct. Termination of employment by dismissal is not without a stigma. It carries with it an infamy. This is why in dismissing an employee with a contract with statutory flavor, strict adherence to the terms of employment and the regulations provided in the statute governing the employment or the public service rules is mandatory. In other words, the procedure of query, suspension, disciplinary hearing must be very strictly complied with. Thus, any breach of the procedure, most especially the requirement of fair hearing, would invalidate the dismissal. The court in Dangote Cement PLC and Agbe had this today. It said termination of employment of an employer, termination of employment of an employee by an employer may be declared wrongful if done in breach of the or violation of any terms and conditions of employment agreed to by the parties in their contract of service, because it constitutes a breach of that contract. The requirement for fair hearing in the process leading to the dismissal of an employee is so cardinal that any interference or any inference of breach will result in the dismissal being set aside, and an order of reinstatement would be ordered by the court. In the case of British Airways and Makanjola, the court emphasized this requirement when he said, it is tried law that where a servant is alleged of wrongdoing and he faces the risk of losing his job or faces other disciplinary measures on account of that wrongdoing, he must be given an opportunity to defend himself. And this he can do by telling his own side of the story. This is an area which the contract of service cannot remove. It is not within the competence of the parties to outlaw the rules of natural justice in the contract of service. It becomes very important, therefore, that in setting out to dismiss an employee for gross misconduct, the employing institution must be very versed and conversant with the procedure entrenched in the public service rules of the Federation and the applicable or those applicable to the states, or the statutes creating the establishment, and any other rules that regulates that employment. Having said so, let us look at what termination by redundancy or retrenchment of workers entails. Section 20 of the Labor Act defines redundancy as the involuntary and permanent loss of employment caused by excess manpower. In the case of Union Bank and Saludin, the Court of Appeal refined redundancy to mean an involuntary and permanent loss of employment caused by an excess of manpower. Redundancy therefore arises where the termination of employment is part of a reduction in the workforce. It is therefore a mode of removing an employee from service wherein his post is declared redundant by the employer. It is a unique procedure whereby an employee is quietly and lawfully relieved of his post. The conditions applicable to redundancy are quite distinct from those applicable to retirement or other conventional modes of determining an employee from service, such as termination, resignation, or dismissal. Now, as stated in SPDC against Nwauka, an employee has no general right not to be declared redundant. Beyond that, beyond what his contract or collective agreement provides. Generally, the condition on which an employee may be declared redundant are found in the collective agreement between the employer and the employees. When an employer intends to declare redundancy or retrenchment, he must inform the worker union the reason for declaring redundancy and the extent of the anticipated redundancy. The employer must also take steps to negotiate the redundancy payment with the employee, with the employees' union. In Obafemi and others against Delta Steel, the Supreme Court state emphasizes when it said, an employer who wants to declare redundancy shall use his best endeavor to negotiate redundancy payment to any discharged worker who is not protected by the regulations made by the Minister of Labor under Section 20 sub 2. I am not aware if the minister has made any regulation in this regard. There may be a need to enjoin the minister to take appropriate actions in complying with his statutory duties. The principle of last in and first out in the discharge of employees affected will be applied. Consideration being had to the skill, ability, reliability of the affected workers. Though the minister may make regulations for the payment of redundancy, the union of the employee in most cases negotiates the redundancy payment to the employees affected. The negotiation and payment of redundancy most of the times creates dispute between the employer and the affected workers, which often results in litigation. The negotiation for the payment of redundancy must be very explicit and clear and must be properly explained to the employees. The payment of the redundancy, in payment of the redundancy, every earned terminal benefits must be paid. You cannot substitute what you are paying as redundancy payment with whatsoever legacy, interest, and terminal benefits the employee has already earned in the employment. Now, having said, consider these thematic issues, I think I would look at how to avoid the pitfalls in terminations and dismissal. Today, about 70% of the dockets of the National Industrial Court are matters relating to termination of employment. Some of the litigations would have been carefully avoided if the parties to the contract of employment had complied strictly to the terms of the employment, the regulations governing the employment, and statutory provisions applicable to the employment relationship. Therefore, to avoid the legal pitfalls, the employers and employees, one, must be familiar with the procedural rules as contained in the Rules of Court, the Evidence Act, because the rules abound procedural technicalities. Two, for the NIC, being a specialized court, counsels who approach the court to ventilate the grievances of their client must be familiar with pleadings in labor matters. They must have knowledge of the applicability of international labor conventions and standards, a mastery of the NIC civil procedure rules, and other labor statutes in very critical for counsels who appear before the court. Our experience in court has shown that some of the cases that are lost in court are due to poor and inadequate pleadings by counsels. Some counsels clearly exhibit poor knowledge of labor laws. This often results in good cases being lost due to knowledge gap exhibited by counsels. One other common flaw exhibited by counsels who appear before the court is that some counsels do not know the remedy they should seek for in the claims they brought before the court. So we find counsels seeking wrong remedies which may not be granted by the court. Therefore, proper knowledge of the reliefs obtainable in particular situations are very critical for the success of the claim before the court. One other significant thing I have noticed about termination is that some organizations allow persons that have no legal knowledge or have no skill in labor laws to handle termination. In the process of doing so, many blunders are committed. And when these blunders come before the court will have no alternative or will have no difficulty in applying the law to correct the blunders, and in appropriate cases, it leads to the claims not being granted by the court. So, gentlemen, This, in a nutshell, are the issues surrounding the thematic subjects that was raised in this paper, which I think with a very robust intervention and contributions, we can have what I may call further development in labor jurisprudence. And I think a good constructive intervention on this would further enlighten the public on some of these issues. It will also enlighten the employers, because most of the problem are caused by the employers, you know. And don't forget the fact that as a labor court, the National Industrial Court, to some extent, is very sympathetic to the weaker party in employment relationship. And the weaker party has always been the employees. So once the court finds any infringement, there's no how. There must be a remedy. The court will always find a way to give a remedy. So with that, I say thank you very much for giving me your attention.
My Lord, that was an enlightening address. Once again, it's a pleasure to have you with us. I must already say, even before the Q&A session, we're already even gleaning some very important and helpful information. Thank you once again for the insights shared. I understand that people will also have questions, but we also have some questions for you. So we'll just go straight into that. From the brilliant address that was just delivered, you referenced the international convention, like the ILO Convention 158 of 1952, which speaks to fair termination processes. In practical terms, sir, how would you say these conventions, how influential would you say these conventions are in shaping judicial decisions, rulings of the NIC, particularly when and statutes appear silent and ambiguous on some of these issues?
Well, you see, if you look at the jurisdiction of NIC, you will see among the templates the power to apply international best practices. We are quite aware of the fact that apart from a very few legislations on labor law, Labor Act, Trade Dispute Act, Factories Act, on Employees Compensation Act, and the rest, with the development of labor jurisprudence, those acts may not contain provisions that would take care of evolving new challenges in this law. That is why the jurisdiction of the court was extended to apply international best practice. It was extended to apply to check unfair labor practice. And what is unfair labor practice? It's just any practice that engenders injustice in the employment relationship between the parties. So we have a very wide, as legal minds, to discern based on our knowledge of labor law, what is wrong, what is not right, what is oppressive. And those are what, these statutes, you understand, that didn't have it that we can apply. And apart from that, the most beautiful thing is this: globally, the world is a global village. What is good in this clan and has been accepted as being good is now becoming part of international norm. And when you see conventions like Convention 158, you realize that it is a collection of all best practices that has developed from some jurisdictions that now form what we call this international conventions and practices. And once you are a member of ILO, you sign those, then you have a duty to come back and implement it at home. That is why we are saying that for now, if we apply these conventions to litigations before us, no employer can terminate his employer without giving reasons. You must give reasons, and you must justify that reasons for that termination to be valid under that convention.
That has been very insightful. Just a final question. During your keynote address, you touched on the distinction between employment contracts with statutory flavor and purely private contractual relationships. Now, we can testify that some employers fall into the pitfall of not recognizing that the employment relationship between themselves and an employee is one that is governed by statutory flavors and statutes. And sometimes they don't take that into consideration when terminating such employment. Would you say a failure to recognize when statutory protection applies to an employee, this failure by an employer, can it be deemed or adopted as a defense in a court proceeding?
No, no, it cannot. It cannot for any reason. Because whether you like it or not, our case law has defined what contract with statutory flavor is. Every contract that has government backing, in the sense that you are employed in the public service of the state or in the public service of the federation as a public officer defined in section 318 of the Constitution, that alone makes that contract a contract with statutory flavor. Apart from that, there are other institutions created by statutes. You should know that no matter what the employer does, as long as you do not own the organization, you don't have absolute control over it, then that employment is one with statutory flavor, as different from the one where a man sets up a private business and decides to employ. So you find out that, like I said, most of the problem is derived from the fact that in setting out to terminate, the managers, the line managers, can decide to allow their personal idiosyncrasies to go into what they are doing without understanding the fact that what they are doing, by the time it comes to the court, because the court has, apart from adjudicatory responsibility, it has investigative jurisdiction. We have to investigate. What did you do? How did you do it? Is it in compliance with the law? Did you follow? So it's an investigating thing. So if you think as a manager or a supervisor, you can sit down in your place, do what you think, nobody can check me. That work is not your own. It is public work. So when it comes for us to look at it, we will tell you that what you did here was wrong. Yes.
Lordship, that was very, very insightful, especially with the distinction between contracts with statutory flavor and those of a private matter. Finally, you touched on the issue of redundancy and retrenchment. Just from your judicial perspective, what advice would you give to employers when carrying out redundancy or retrenchment exercises?
Right now, when I leave here, I'm going to speak in a workshop organized by NDIC. And the topic is adjudicating pension and terminal benefits in banks liquidation. Have you ever read the NDIC Act? The NDIC Act, which I'm going to talk about immediately I leave here, only talks about payment of deposit, insured deposits. Now, once a banking license is withdrawn, the next thing NDIC does is to move in, take over the bank. In most cases, they don't pay the terminal benefits of the workers. The question is, can you deny those workers those rights? You cannot deny them. In fact, before you even start the act of liquidation of the bank, you must take care of the liabilities, the salary liabilities, because by then you would have declared redundancy. You are going to lay off all the staffs of the bank. You must first of all settle that remuneration liabilities before you start talking about depositors. But there's nothing in the act that talks about that. But rather the act keeps talking about protection of the liquidator NDIC from all litigation before, during, and even after the liquidation. Now, you find out that until the employer understands that redundancy comes with some liabilities, then there will still be problem in that area. And good enough, it is so far beautiful that in Section 20 of the Labor Act, in recognizing the fact that terminal benefits must be paid, the law is that the minister must set templates for payment of redundancy. And where the minister does not set that, then the employees' union must negotiate redundancy.
You very much, Your Lordship. That has been very insightful. So, Mrs. Ozom, we can agree that the labor terrain in Nigeria can be tricky when it comes to issues around termination and dismissal. And I believe you have a good level of experience, even on the academic side. So I'll be jumping into the first question we have for you here today. We understand termination is a sensitive issue, and this must be handled very carefully to avoid any legal consequences. From your experience, both on a practical side and also on the academic side, what would you say constitutes a lawful termination of employment in Nigeria and under the law as we know it? Can you also please turn on your camera, ma? So that might also help with the communication. Thank you.
Okay, termination. When it comes to termination can be done in compliance with the law. That's like Section 11. Section 11 sub 1 has actually said how this termination can be done, and which it actually says how this termination can be done. And also, if there's an employment contract, it must actually be done in compliance of whatever is in the employment contract. As we already know, parties are bound by their contracts. But if there's no contract, the law says that when there's an employment which is less than 3 months, then the employee has 1 day notice to give. So if there's actually an employment less than 2 years, the employee has like 1 week notice to give. So if it's actually less than 2 years, but more than 2 years, but less than 5 years, then you have like 2 weeks. And if it's above 5 years, then you have 1 month to give. Let's take this for instance now. You have an employee who has an employment contract which says that both parties are going to give 1 month notice if they want to terminate, either each party has to terminate. For instance, now Mr. Okoro wants to leave the employment and wants to leave the employment and gives a 1 month notice on the 1st of September, stating that he is going to leave the employment on the 30th of September. So with this, you can see that Mr. Okolo has actually, and in the employment, Mr. Okolo has actually worked for more than 5 years in the private organization, but you could see that Mr. Okolo has actually given 1 month notice, which is in compliance with his contract. And Mr. Okolo is also in compliance with Section 11 sub 2D. So you can see how this termination is being done, because once, to avoid anything cut, you have to look at what the contract says. If the contract says you must give 2 months notice, you must give 2 months notice. Either party will give 2 months notice, or you pay payment in lieu of notice. So even if you go to court and there's a termination, the first thing the court will look at is the contract. What does the contract say? And that's where the court will actually start from. Thank you.
Mrs. Unzon. That was very, very, very insightful. Just to also go to the next level on issues surrounding dismissal. Can you please walk us through the recognized grounds for summary dismissal under Nigerian law, and how employers can execute such dismissals in a lawful manner without exposing themselves to any disputes from employees who are being dismissed? Thank you.
Okay, thank you. When it comes to summary dismissal, even if you go to Section 11 of the Labor Act, Section 11 did not mention anything about summary dismissal. You would actually not see anything about summary dismissal. But if you look very well at probably that Section 11(5), we said the employer can actually terminate with reasons which they feel is actually reasons. So for you to talk about summary dismissal, something must have come up. And summary dismissal means you're actually going to dismiss the employment without notice, without payment in lieu of notice. So what has happened? That's what we check. There's a fraud, yes. There's a gross misconduct, yes. Probably there's a document, because when there's an employment contract, there are actually going to be terms in the employment contract saying, oh, you shouldn't do this, you should do this. And if any party, if either the employee violates any of the terms of that particular employment contract, then you could see the person can actually the organization can bring application for summary dismissal. Notwithstanding that you can do summary dismissal can be done, but it must be done in the right way. Now, we have to bring Section 36, which says that both parties, the party must be heard. You can't just say, oh, because of Mr. Bello is having issues with the manager fabricated things, and the manager said, oh, this is a gross misconduct. Mr. Bello has to be dismissed. No. So now the law says that you have to set up a panel. Mr. Bello has to be heard. There's a gross misconduct against you. What do you have to say about it? And all these procedures must be very fair, because whatever is going to happen there, definitely if Mr. Bello decides to take it to court, the court, like what my lord said, that they have investigative powers, they can still investigate. The court would want to know, oh, what really happened? Was a proper investigation done? Was parties heard? So if all these are done like in the right way, and definitely Mr. Bello was actually the accusation brought against Mr. Bello, and Mr. Bello was found guilty of it. Yes, summary dismissal can be done, but everything must be done in the right way. Thank you.
Thank you so much, Mrs. Unzom. I believe that as educated employers in the house on how to part ways with staff without stepping into some sort of legal battle or legal storm. Like I said earlier, Mr. Bello operates where the law and real world corporate decisions come together and collide. So we'll be turning now to Mr. Bello, and I'll just be cutting to the chase. Mr. Bello, wrongful dismissal claims continue to be a consistent area of employment litigation. In National Industrial Court now, you see cases being filed every day for wrongful dismissal claims, termination claims, non-payment of salaries and whatnot. What do you have? From your perspective, sir, what are the common grounds on which employees tend to file for wrongful dismissal at National Industrial Courts?
Okay, thank you very much. Again, it's a pleasure to be here. I think the common grounds, or what we will call common grounds, are quite not exhaustive. So because the labor world itself has got through a lot of dynamism, let me put it that way. So you find many things happening why an employee these days can find a ground that is unknown some 15, 20 years ago, before the Third Alteration Act came into enforcement. Generally, I think the first thing is the fact that for wrongful dismissal, dismissal itself is something that arises out of misconduct of an employee, by which the employer wishes to discipline that employee for a wrongful conduct, which I believe the terms of contract or the handbook or the manual must have called a misconduct. Unfortunately for employers, sometimes they don't go through the rubrics of following laid down procedure, particularly the ones which the law imposes. For example, the rule of fair hearing is cardinal in the dismissal of an employee, even where that employee has committed a barefaced misconduct. What are some of these rule of fair hearing as enshrined in the Constitution? Remember that we always talk about the employment contract being the main guide of what happens. But assuming, for example, that the rule of fair hearing is not embedded in the contract, you will find out that because the Constitution, Section 36, which talks about the rights and liabilities of parties in dealing with each other, enforce or makes it important for employers to ensure that they go through or they follow the rules of fair hearing. So what are some of these? Number one, the employee must have a right to receive notice of allegation. That is cardinal. You cannot punish me when I have not even received the notice of allegation. Second, I have a right to respond to those allegations. If you accuse me, it is only fair that you allow me to respond to the allegations which must be made, and that is, of course, the right to be heard. Secondly is the fact that I have a right to, if you're taking me to a panel, I have a right to an impartial panel. For example, if somebody has accused me in the office of doing something that constitutes a misconduct, I don't expect to sit that person in the panel of judges. Once I sit that person, I can allege bias, and fairly so, because that person is the accuser, and at the same time, he's going to judge me at the end of the case. You cannot tell me that that's an impartial panel. The fourth one is that I have a right to call witnesses and to present evidence. If you accuse me of something, and I say I have witnesses who can lend credence to my innocence, then you must just give me the right to call those witnesses to present the evidence. Also, where there are rules embedded in the policy handbook, which are usually incorporated into the contract, you must follow. Non-following any of those rules lead to the voiding of any decision. Also, there are situations where I want to put forward certain technical arguments. You must give me the right if the rules allow me to. The only thing, that that makes it a bit that's a bit controversial here is whether or not an employee has a right to call a lawyer to represent him. Of course, Section 36, usually people will make reference to Section 36, which says that when it comes to the rights and liabilities, particularly in the criminal sort of setup, a person has the right to a lawyer of his choice. But there's also the need to balance whether or not an accusation in an employment position is one that requires or that mandates the right to call a lawyer. Honestly, my advice to most employers is that if an employee says that, look, I want a lawyer to represent me in this panel proceedings, I think you should give the employee the right to exercise that right. So these are some of the rights. There are also some, as I said, there is a dynamism that is moving in the employment sector now. Another question will be that when an employee has seen that, look, there are certain things that had happened prior to his dismissal or termination. For example, I have made a complaint against one of my bosses, and it happens that in a bid to witch hunt me, they said that they are going to deploy me. Let's say I work in Lagos now, and because I complained against certain things happening in the organization, I was moved to, let's say, Zamfara, and I was demoted from being an associate director to now a manager, for example. And I said that, look, why are you changing the terms of my employment suddenly? And then you say that, look, if you know you're not taking it, you are advised to resign. It becomes a ground for me to challenge that kind of termination. When work is preceded by a visible hostile working environment that makes it impossible or unreasonable for me to continue to live, to work in that environment, it is a ground for termination. So you will find there are significant changes in the terms and conditions of an employee that makes it impossible or unreasonable for that employee to continue in that employment is a ground for termination. Thank you.
Thank you so much, Mr. Bello. Just a final addition, because your answer exhausted a lot of angles to this. Just a final one. I had earlier asked Mrs. Unzom on what practical steps employers can take to minimize the likelihood of such disputes. Is there anything you would just like to add to that? Practical steps that employers can take, employers in the room can take home and add to their policies.
Very good. Thank you. I think the first thing employers need to do is to ensure that, number one, they have well-drafted contracts, policies, and procedures. And these contracts must avoid ambiguities, ensure that, look, they are brought to the attention of employees and that they sign off on some of these policies. Also, employers these days, particularly the small boutique employers with less than 20 to 50 staff, they don't want to seek legal advice. And I think as lawyers, we need to let our employers know that legal advice is very critical at this 21st century labor law. Our labor law jurisprudence has moved from master-servant relationship into a more dignifying position. So they must seek legal opinion. They must get lawyers to develop a checklist that allows them to tick the boxes in terminating an employee's employment. You must tick boxes. What are the things we need to do? Then you must ensure proper documentation history of the behavioral disciplinary actions that may have been taken against an employee. If you have an employee, for example, that you've seen that has exhibited series of antecedents, which you have queried, which you have warned, which you have had discussions, or you have an employee that has not been performing adequately in accordance with this set KPI, or what you call key performance expectation, you will have discussions with this employee and document it and make it very important, particularly to what we call the line managers, to have these discussions in a manner that reflects the actual discussion, such that the employee will sign off. What these things do is that by the time you want to exit an employee, for example, for non-performance of the key performance indexes, you can bring this documentation to bear and then exhibit it as part of what you're exhibiting before the court to justify. Also, ensure as employers that when an employee is not performing adequately in accordance with your set expectation, you work out a balance, in which case you're not just exceeding because of non-performance. You can place the employee on what we call a performance improvement plan that ensures that you've done the best you could for that employee to excel in another department. You can put in that employee in a work rotation. Okay, if you can't function in legal, can you function in a regulatory department? Let's see what you can do for another 2-3 months. But document it so that by the time the person is going to court and saying that, look, it is because they don't like my face, oh, they are victimizing me, you have documents to show that, look, you have been given all opportunities to improve yourself, but all those opportunities have failed. Also, it is important that as many times as, and because work is dynamic, you will find out that employers change policies and procedures that may affect employee rights. It is important that these changes be communicated to employers and employees, and for them to sign off in a manner that makes it, collaborative. You see, employers and employees now collaborate, they engage. There are town halls that makes it, a very open and frank discussions that make both parties able to come to decisions and agreements. And employees must be given the opportunity to have their way, or to have their say, and sign off on some of these changes. Then lastly, employers need to build in an in-house dispute resolution mechanism that makes disputes easily managed from one end to the other. Create levels of managing. From your line manager, it goes to another superior officer, to another superior, in a manner that is convivial and not necessarily atrocious. Also, I would think that it is important to resolve these disputes in a timely manner. Then train managers to be empathetic to employee situations. And I think most important, keep your employees happy. Pay them bonuses, make them happy, make them want to come to work. And I think those are some of the things that makes for reducing risk in employee and employer matters.
Thank you so much, Mr. Bello. What I have been able to pick is that employment exits are not things you can just jump into. Employers have to take their time, properly document, make sure all internal remedies are exhausted before that very serious step is taken. Now we'll turn to our very own Mr. Additional. Like I had said, Mr. Additional is somebody who not only is a legal practitioner, can confirm he understands the business of the law. He has seen the good, the bad, and the avoidable when it comes to employment exits. Mr. Additional, you are welcome once again. In kicking it off, Mr. Additional, I would take us a while back to the COVID-19 pandemic, when a lot of companies globally and locally could not cope with the economic realities of having a lot of staff on their payroll. And there were a lot of redundancy exercises, retrenchment exercises. So this is an area that is commonly confusing when it comes to matters of employment. To set the stage in helping us understand the jurisprudence of retrenchment and redundancy, I would ask, what is the legal definition, or how would you describe the concept of redundancy under Nigerian law, and what procedures must employers follow and implement in a redundancy exercise? Thank you.
Thank you very much, David, and thank you for this opportunity. Redundancy, as a person, is something that I'm very passionate about. It is very dear to my heart for two reasons. One of the reasons is that, look, when it happens, it does happen without the fault of the employees, neither is it the fault of the employer. It's just a business decision, right? When it happens, and then you have to go down that route to ensure that you have operational efficiency. The second issue on redundancy basically is that it's so dynamic. It's no two redundancies are the same. Redundancy in company A or company B, even though we have some laid down procedure in the Labor Act, may not be the same in terms of implementation and outcome. And I'll give an example. A few years down the line, a company in the financial sector actually wanted to acquire another one. They were in the process of the acquisition, but preparatory to that acquisition, they also engaged and employed employees in readiness for operations. Some of those employees were expatriates, funny enough. So eventually, that transaction fell through and it wasn't going to happen. What did they do with the employees that they have engaged? Some of them were expatriates. It then became not just a redundancy. For the purpose of this discussion, it became a cross-border redundancy. Quite very interesting. That is why I said that, look, redundancies sometimes can be very peculiar to company, and you have to look at them from a legal point of view, from pragmatism point of view, to achieve a solution. And I think the last speaker, Benga Bello, did mention that it's a time that we need to be empathetic when situations like this arise. So to your question on what is legal definition of redundancy, his lordship, I did mention and refer to the Labor Act as well, when he said redundancy is an involuntary and permanent loss of jobs as a result of excess manpower, right? That's on the statutory point of view. On the case law point of view, redundancies have been defined in different cases, including the case of and Salim, right, where it was said that it's a quiet and legal way to ease out employee. Some other cases have defined redundancy to say, look, it's a pragmatic step towards reduction of workforce to achieve operational efficiencies. So if you look at it by and large and the contents of the Labour Act, you would find that it defines redundancy, but does not stipulate what or in what cases can you say you need to go or declare redundancy. So that is not in the Labour Act, which is the enabling legislation. So scenarios where the redundancy can occur may be one of these. But like I said, you need to articulate it. You need the services of a legal advisor to be able to identify whether or not you have a redundancy in your hands or what you have is something other than redundancy. So redundancy, for instance, are occurred in situations where there are mergers, acquisition, corporate restructuring. They had occurred where there were downturn in production as a result of shortage of raw materials, which means that the number of staff that are in that production line would have to reduce because there were no materials for them to work with, right? Also, like I mentioned earlier on, redundancy could occur when there are operation efficiency requirements. It's not your fault. It's just that the company is experiencing financial issues, and as a result, he's desperate to stay afloat, in which case they would have to right size or downsize, as it may be called. So those are some of the scenarios where you have redundancy. With respect to the procedure, right, and this is where pragmatism comes in. First, for me, is you need to ascertain whether or not you have a redundancy situation at hand or there are other alternatives. Alternatives such as role realignments, alternatives such as transfer of those employees to some affiliates or subsidiaries. But if you have explored all of those and you still think that, look, some right sizing needs to be done because of redundancy of certain roles within your company, then you can then go ahead to say, look, I have a situation at hand. We need to declare some roles redundant and then implement accordingly. I'll give another instance with respect to this ascertainment of whether or not you have a redundancy at hand. We were involved in a matter, and then we had gone like maybe about 20% into the work. And while we are looking at the employment documentation of the company, we then realized that for that particular company, they needed to have a business case prepared by management that would then be approved by the board of directors before they can proceed. So when we stumbled on that and we said, look, guys, you didn't bring this document to us when we asked. As it is, we need to store. You need to go back and look at the possibility of drawing up a business case that would justify this exercise that you're about to embark on. Again, this one was in the financial services sector. And that happened, we got approval, we moved on. So first is you need to ascertain whether or not you have redundancy, or that can be avoided by way of role realignments or transfer or some other options available to you. Having said that, then you need to look at your pool of employees to see, look, do we have some redundant roles, fine, but all of these people that we are looking at, do they really fall within what we want to implement in terms of redundancy? If the answer is no, then you sieve those guys from the other guys that will be impacted really and truly by the redundancy exercise. What am I saying? If you look at your pool of staff, you may find, we've seen it in the past, some employees who are outsourced employees to your company, right? So there's a different way to go about that. That's not within your remit to declare them redundant, right? You may also find some employees that have fixed term employment, which may be nearing the end of that term and all of that. You have to approach that differently. You may also find some that are under probation, right? And you look at that as to whether or not you want to subject those ones to the principle of last in, first out, right? So that's the second stage. The third stage, after resolving that, look, you have a redundancy at hand, is for you to engage. So if you look at Section 20 of the Labour Act, it says, look, you must engage the employee's representative, right, or union to discuss first that you have a redundancy at hand, the extent of the redundancy, those that it may affect in terms of rules, and also the remuneration. usually you would have had that documented in the CBA for the employees that are under the union. When you have a situation where the employees are not unionized, or some of them are not unionized, you may have to engage also with them to say, look, we have this situation at hand. It may get to this level. When it gets to this level, these are the people that may be impacted, and these are what we are looking at in terms of how to look at their how it affects them and how to ameliorate the impact on them. So, and that engagement must happen. And in the engagement also, employees are free to suggest to you to say, look, why are we doing this? Why not role realignment? Why not transfer? Role realignment will be subject to whether or not you have the skill set to play in that other role or to perform in that other role. If you don't have it, then you may not fall in that. But engagement will happen on how can we have an issue in the company? How can we go through it? Can we avoid this redundancy and retrenchment exercise? If the answer is yes, then you should consider it. If the answer is no, it has to happen, then you proceed. So once that is done in terms of engagement, the other part that would happen is also you need to look at consider your best efforts and endeavors as an employer as to how to remunerate or how to compensate those that will be affected by the redundancy exercise, right? That's on retrenchment. But I mentioned earlier on, before you get to that stage, that you also have to apply the principle of last in, first out. So in some cases, those have been contested by some impacted employees to say, look, it suggests that there's some predetermined discrimination against them, being that they are probably the newest to join the company and they're performing very well. But gladly, the Labour Act has a provision in it that speaks to some qualification as to how to implement the last in, first out principle. And it says that you can do that subject to some merits, subject to ability, subject to skills, and subject to reliability. So if you look at all of those four, I still think that those that came in last should be retained, then the law allows you to do that. Also, our case law in terms of jurisprudence governing employment relations also allow you to do that. So by implication, those are the steps and procedure that you need to follow. It's very unique, and then you must treat each case on its merit, as in isolation, as opposed to, oh, it happened this time in this company a few years ago. It's happening again. We are going to follow the same route, because when you get to engagement, when you get to the issue of compensation, which we probably will get to at some point, the discussions can be different depending on, first, the people that will be affected, the number of years in service, also the financial state of the company has to be considered in all of those discussions. So no two redundancies should follow the same route other than this general framework that we have explained in terms of procedure to implement a redundancy exercise. I will stop there at this time.
Thank you very much, Mr. Additional. That was very astute, I must say, and very enlightening. I think that has shed a lot of light on issues around retrenchment and redundancy for employers in the house. Like I said, lastly but not least, we will now turn to our own Mark Williams, who is no stranger in helping employers handle contracts, variation talks, and review of contracts. So, Mr. Williams, to cut to the chase, we understand that in general principles of contracts, terms can be varied across different contracts. Now, since an employment relationship between an employee and an employer is also deemed or is also governed by a contract, can the terms of such a contract, like any other contract, be varied under Nigerian law?
Thank you very much. Thank you very much, David, for that lovely question. Well, yes, employment contract is like any other contractor you can think of conventionally, but employment contract is quite unique. It is governed by law, the relationship between an employer and his employee. So the legislation that we have to fall back on in answering that question is actually the Nigerian Labour Act. Now, of keen interest is Section 7 of the Nigerian Labour Act. Well, Section 7 suggests that an employer can vary the employment contract of an employee. Now, Section 7 sub 1 mandates that an employer should, after the engagement of an employee, provide a written statement for him stating what I call the conditions of his service. There are about 8 or 9 items under section 7 sub 1A, of which a few are the nature of his employment, whether the contract is for a fixed term, whether there are any special conditions in the contract, the rates at which he will be paid, his hours, and so on and so forth. Yeah, but on special interest under that section 7, which I think better answers this question, is section 7 sub 2 of the Labor Act. Now, this section 7 sub 2 stipulates that an employer must, if an employer wishes to vary the terms of engagement of an employee, he has 2 options. Now, those 2 options, the first one is not more than 1 month after the change is made, inform the employee of the nature of the change, and he must do this by a written statement. The second option open to an employee is to leave a statement for the employee and preserve it for the employee so that he has reasonable time in the course of his employment to come across such a document. You can understand. So the key takeaway here is that an employer can vary the terms of a contract, just to answer your question more directly. Yeah. Thank you.
Thank you, Mark Williams, for that illuminating answer. Before I go to my second question, to the members of the panel, please, we are getting a lot of questions in the Q&A chat box. So I would kindly ask every member of the panel to please take a look at the questions in the Q&A chat box. Pick one particular question you would love to answer. That's for each and every panel member, so that when we finish with Mr. Nwogu, we can dive directly into answering those questions. And to the participants, please, because of time constraints, we might not be able to answer all the questions, but remain rest assured that any question that is not answered here by the panel, answers will be provided in due course from our firm. Thank you so much. Now we're going to my second question, Mr. Nwogu, and this is a very practical question from my perspective. What would you say are the reasons why employers would ordinarily want to vary the terms of a contract?
Yes, thank you very much. The employer runs a business. So the business has dynamics. One way or the other, things change. So why things change, it will influence the way business is done. So just to state a few, the reasons are just open-ended. There could be more, but I know, but just I've highlighted just a few. One of them could be for business needs of the employer. Perhaps the employer wants to reorganize, or like just Mr. Adeshina said, there is a merger. When you merge 2 companies together, most definitely it's going to affect the contracts of various employees. There may be need at that point in time to vary the contracts of the employees. Also, there could be a need to comply with new laws. For instance, somebody is earning 25,000 naira, as paltry as that, I understand, but somebody is earning 25,000 naira as his take home. Now there is a new minimum wage passed by the Nigerian government. There is no way the employment contracts of employees would not be varied to up it up to 70,000 naira or more. That is applicable now in Nigeria. Also, the employer may want to do crisis management. We've made quite a few mention of the COVID-19 era. It was a disastrous time. People's employment contracts would normally state, like I said, what section 7 sub 1 said, the amount of hours of your work and all that. It could also state you must come to the office Monday to Friday. But during the COVID-19 pandemic, it was not practicable that somebody would leave his house and come Monday to Friday. So there was need as well for employers to vary contracts, to say, okay, now you mustn't come to the office, you can work from home. You see, this kind of dynamics would help or influence the decision of an employer to vary contract. Also, the employer may want to, be competitive in the market. The employer would want to increase bonuses for his employees, at least to retain them. With that, he would have to vary their contracts. Your employer, any change in that comes that you're not aware of from the beginning, the employer should at that stage inform you one way or another, make you aware of it eventually. Also, performance of operational needs. Your employer wants to increase your KPIs. He wants to change your job description rules and all that. You're not performing here. He wants to take you to this other place. He would have to vary the terms of your contract so as to ensure that all is home and dry. Then lastly on my list, economic factors. There could be recession. There could be inflation. The business is running out of money. They want to be redundant. Something would happen to the terms of everybody's contract. If it's already not spelled out, something would have to happen to your contract. So there could be variations there. So these are just a few. It's open-ended. There could be more. There could be better ones, but these are the few I could highlight. Thank you.
So much for the illuminating answers, Mark Williams. We appreciate your presence on this panel. I also want to thank once again the 400 participants in this session. We do not take it for granted. We thank you very much for participating in this general discussion. Now, like I earlier said, we will now open the floor to the questions from the audience. So, Mrs. Unzom, I will be taking your question first. I believe you have identified the question that you really want to answer from the audience. Hello, Mrs. Unzom.
Okay. I'm actually going to take the question on. I'm trying to look for the question. What they actually talked about the burden of proof when it comes to the burden of proof. Sorry. Okay, looking at the question when it comes to the burden of proof, when it comes to dismissal of misconduct, she actually said who bears the burden of proof. Definitely is actually the employer. It's actually going to go to the employer will bear the burden of proof because he's the one saying an offense has been committed. So definitely it's going to be the employer, but it's actually going to be based on a balance of possibilities, which is kind of a 50-50 thing. But for what I've said earlier, there must actually be a panel. There must actually be a panel which must be investigated, and the employer has to bring all the evidence it has. And also, if he's involved, if he's actually involves an offense of criminality or fraud, they would actually need a police investigation or a report to it. Yes, that's all for. Okay,
Thank you.
That's okay. I wanted to take. There's another one which someone talked about. Sorry, can I take two? One is good.
Sorry, 1 minute, Mrs. Nsom, so we can be able to go around. 1 minute, you can answer, yes.
Okay, sorry. Someone also talked about giving an employment contract with a 5 months, 7 months notice. With that, it's actually the unfair contract terms would actually apply because Section 11, subsection 11 already says the notice period. So in drafting your employment contract, the notice period must fall within what is actually contained in the employment contract. So if you're giving an employment contract saying, oh, there's 5 months notice period given, no, then the application of unfair contract terms will come in. So thank you.
Thank you so much, Mrs. Unzom. Those were very, very great answers. Now I'll move on to Mr. Bello. Mr. Bello, I'm hoping you have identified a question you find very intriguing and interesting and would love to provide an answer to.
Yes, I have. Thank you very much. The first one I think is from Tony Atama. It has no, sorry. well, I can't get the name now. I think it has to do with being advised to resign. What is the position of the law when a company tells an employee that he's advised to resign? The simple answer is that when you advise an employee to resign, what you've done is to constructively dismiss that employee. Resignation is a term, or is the expectation is that resignation must be willing from an employee. So if you want to discipline an employee and you say you better resign from my employment, what you are telling that employee essentially is that you are dismissed. And if that resignation does not come willingly, in fact, in the case of, I think it's there's a case in which the National Industrial Court, awarded 1 million naira damages against an employer who simply advised an employee to resign. Somebody asked a question about training bond. I think it's Bimbo Ogundaini, and said, what is the current position with training bonds? So first, let me say that training bonds are agreements between employee and employer, in which the employer agrees to train an employee. Usually these trainings are ones that are quite expensive, and the training is such that the expectation of the employer is that the employee will be in the employment of that employer for a certain number of years. And if within that certain number of years that the employee has bounded himself or herself to be in the employment of that employer, decides to leave after having enjoyed the training bond, what is the position? At first, it was difficult. I mean, I was in the bastion of lawyers who argued about 5 or 6 cases at the industrials where we held that training bonds are restrictive covenants which avoid ab initio. They are negative in their construct, and because the employee is in disadvantaged position, the training bond is not binding. We were able to succeed when we argued Overland and Captain Jam that when an employer sends out an employee to train on a special training, particularly one that benefits note this, particularly one that enables the employee to make optimal position of his employment. For example, a pilot who could not fly a plane was sent to fly to learn a training course in France, thousands of dollars. And then you came back and you started flying the plane. The expectation is that you will fly that plane for at least 5 years. Now, in your second year, you say that cannot be fair. And I was glad that, the only thing is that what happens is when you want to leave as an employee, what the industrial court does is to cascade and ensure that the amount the employer is going to get is going to be one that takes into cognizance the number of years which that employee has put in. Somebody also has a question about withholding accrued salary upon dismissal. I understand that to mean that if you're dismissing an employee on the spot for something he has done, and the person has earned an amount up to the point of dismissal, can the employer withhold that accrued benefit? The answer is no. The National Industrial Court has held that benefits or wages that have accrued before dismissal must be paid upon dismissal. So if, for example, I've been working from June 1st and on June 26th, I was caught stealing in my office, and my employer gives me a query to give reasons why I should not be dismissed, and I answer, and that answer is not tenable. If I am dismissed as of that day, the law is that I must be paid from 1st of June till the 25th, at least, of June before I am taken out of the company. So these are some of the few questions I have picked from the question and answer box.
Thank you, Mr. Bello. Those were really great answers. I'm sure the employers in the house have really learned a lot from the answers you've given. Mr. Adeshino. Hello, sir. I don't know if you've also been able to identify questions that you found interesting to provide answers for us today, sir.
Thank you very much. As Mr. Bello was going on and on, I felt like he was going to take all the questions. And incidentally, he took some of those ones that I had identified. But let me answer some other questions that he didn't touch. I'll just put some addition to the training bond that he mentioned very quickly. Is spot on everything that he has said. The other issue that I think I should add is the length of the restraints, right? 1 year, 2 years, 3 years. The court will look at it and then look at the reasonability of the number of years that you want that employee to stay to determine whether or not that will be enforced in terms of length, right? But everything that I said, I align myself with it, particularly if the employer can show that they expended money and that all that training is required for your function, right? So that has to be documented to say this happened. So then they will do. There's some restraints of trade that really you would see that there's no consideration. Training is in-house and all of that. That may have some commas, but I just wanted to touch on that. In terms of length, it will be on reasonability, or it will be subjected to reasonability test as to the implementation. The other question there is suspension without pay and what remedy an employee has. So there are two types of suspension that you can have: suspension pending investigation, right? And then suspension as a disciplinary action. If suspension is meted pending investigation, then the employee is entitled to his or her remuneration. So you can claim that if it's pending investigation, because it's not expected to last forever. That's also an incentive for the employer to make sure that it's done timely and speedily, and all that is needed obtained. But if you leave it open-ended without pay, then there's a high chance that it may lead to what Mr. Bello called constructive dismissal, because that is wide in its sense. So, but if it's as a disciplinary action, then you are not entitled to pay suspension. So that's on suspension. There was the issue of, there's another question on where employee resigns before resumption or withdraws his consent to a letter of employment before resumption. That, if you ask me, if you go through the basics of offer acceptance, consideration, intention to break regulation, if you have signed, you have signed. That has happened. You should resume, right? But then you can, where it gets tricky is whether constitution has passed, right? You haven't earned salary and all of that. Can you? But if the employer can show that preparatory to your resumption, they have made some provisions, they've taken steps, your office has been set up, they've got this, they've done this, they paid for your XYZ, right? Maybe your what's called health insurance and what have you. Then there is some remedy that should go to the employer, even if you resume, if you refuse to resume, you know, on the resumption date. That's the second one I thought I should touch on. I saw one question, but it looks like it's been taken out. And I can't remember the name of the gentleman that asked the question, but or maybe he edited his question. Let me see if I can quickly see that. It was on redundancy. I can't see again. I'm checking the name very quickly because I remember the name.
I will. I just saw some other questions which just pricked my attention. Somebody asked James Ehidiamen, when is the time to pay in lieu of notice upon termination? I must say it is immediate. The effective date of termination is the date you must pay. Anything after that, then what you're telling the employee is that, in fact, you're telling you are breached. Once you don't pay, it is a breach for which an award of damages will ensue. You also asked, how do you determine damages in wrongful termination of employment? Now, typically before the third alteration, essentially what will usually happen is that the court will apportion such payment as will restore the employee to the position he would have been if the contract has been performed, in which case the court will go into your contract. If the notice period is 1 month, you get 1 month's salary as damages. If it was 2 months notice, you get 2 months, and like that. Now, the NIC, applying international best practices, and said, look, the whole situation must be taken in one fell swoop before an apportionment of damage, and particularly when some untoward behavior had been meted out to the employee. For example, if you have a case of somebody who had been victimized or somebody who was advised to resign, those things are taken as torts. And the Supreme Court recently, in the case of Skybank and Abekunde, put everything to rest in a judgment that is so. And I advise everybody to go and see that case. I think it was decided in 2024. Skybank and Adegun. The Supreme Court applied international best practice in that case. In that case, what had happened was that somebody who had been an employee of a bank, and which bank merged with Skybank at that time. At the time before the merger, the guy had been singled out for certain fraudulent activities, which at the time of merger was not discussed. And at the time of merger, the merged company now opened up that fraudulent case again and disciplined the guy by dismissal. The Supreme Court, amongst others, said that no, estoppel arises when you have led the employee to believe that you have done with the case. You have now merged into another company, meaning that you have offered a fresh start for that, and the person has relied on the representation that he has now joined a new company. You cannot hold him bound to the offense or to the misconduct which you have dealt with. Going on, the Supreme Court said it is not international best practice for you to discipline somebody by dismissal when you have not given a reason for what you have done. And thirdly, the Supreme Court said that in giving a reason, if you are not giving a reason, the amount of damages that will be paid against by the company for it will be the one that will compensate the employee into a position that all emoluments he would have earned will be earned from the time the wrongful act occurred up until the day of judgment. And you've seen the National Industrial Court awarding as much as 14 million. So in fact, we've seen 100 million in some cases. The Supreme Court has now adopted some of these principles as part of the international best principles in keeping with the current realities in modern legal jurisprudence. I just thought those were very, very, and somebody, I think it was Abiola Sani, who said fit to work. If somebody is terminated or somebody was employed for a particular work which required that person to be fit for that particular work, and as now, because of something that happened, the person is no longer fit, should that person be dismissed, or if that person is terminated, and I think the National Industrial Court in many cases had and I want to advise employers, these are very tricky questions, and each circumstance must be taken in the facts. There was a case of a lady who worked with an hotel. While in her work, they subjected all of them to tests, and it was discovered that she had HIV. And on the basis of that, or about a month or so later, she was dismissed or terminated. And the National Industrial Court held that that was discriminatory. So what I have gleaned from the happenings here is when somebody has been subjected to a test, one of the things the industrial court will look at, and I like the way the person framed the question, he said, if you had been tested prior to your employment and you were found fit, and later you were not fit to do the carry, I think the better way to do it is to manage the situation. Put the person on what will come a sort of a garden leave. Let the person enjoy salary for some time without managing your situation. We still want you to earn something. And when you're going to ease the person out, make sure that the person has benefited from a payment that makes it possible for the person not to even, then find what I would call a reasonable package, a payout package, so that by the time the person is leaving, and even if the person goes to sue in court, the court will have seen that the employer has taken a reasonable measure to put that person in a position where he will not suffer as a result of losing his livelihood. Thank you.
Wow. Thank you so much, Mr. Bello. Thank you so much, Mr. That has been enlightening. Is Mr. Additional?
Yes, I saw a question. I saw a question on whether or not severance pay is mandatory. And I think that question was asked by Blessing Ime in a redundancy situation. Yes, it is very mandatory to pay a redundancy benefit or severance pay. And that pay, when my lordship was delivering his speech or his paper, he did say that, look, that pay is different from all other contractual rights or benefits that the employee already has. So, for instance, gratuity, because some companies still pay gratuity in spite of the Pension Reform Act, right? End of long year service pay, all of those that are contractually stated, he will still be entitled to it. What you are negotiating is what payment should be made to him to ameliorate the impact of redundancy that was not as a result of his fault. So yes, it is mandatory. That position is also supported by, I think, Section 21C of the Labour Act that says that employers should use their best endeavor to agree on redundancy payment to the employee. So in any event, whatever contractual financial benefit you already have, the severance benefit is an addition to it and it must be paid. The quantum is a different discussion.
Mr. Additional. So in 3 minutes, we are going to take one person from the audience to throw a question to the panel. The question and the answer has to be given in 3 minutes so we don't run out of time. We'll be picking somebody from the audience. So Mr. Larry Fashola has a question. His hand is up. So we'll be giving him an opportunity to ask that question.
Good afternoon, everybody.
Good afternoon, Mr. Fashola.
Anyway, it's just about afternoon anyway.
Yes, sir.
Yeah, I've been following the discussions and I found them very, very interesting and relatable. I'm from the public sector and I deal with
Mr. Fashola, can you type your question?
The madam that spoke earlier spoke a load, which is very, very crucial. Can you hear me? Hello?
We couldn't really.
Hello?
We couldn't really.
Go on, sir.
Mr. Fashola,
Can you hear me?
Yes, go on.
Yes. So cut it very short. It's more of a comment than a question. The issue of investigative panels, I realize that the burden of proof in those panels can be very, very controversial. An employee is accused of, let's say, for instance, stealing, and is brought to a panel of investigation, and you can't really prove that allegation against the employee beyond reasonable doubt. Just probably you felt like, well, the employee has actually done this or made this infraction, and on that basis, you dismiss that employee. So what kind of risk does an employer is exposed to in this regard? That's my question. Thank you.
Okay, I can jump on that. It's quite an interesting question. So to start with, the rule of beyond reasonable doubt does not apply when it comes to investigations for misconduct in an employment. That's for the court in criminal proceedings, so it doesn't apply. What would apply is whether or not that employee has been given the opportunity to present his case and is heard, right? Once you have heard, the issue then becomes whether or not the panel reasonably believes that you actually committed that offense. You can say that in a way may not entirely be correct in terms of outcome, but what the law says is that once they believe that you reasonably committed that offense and all of that, then they can dismiss you. They can dismiss you, sadly so. But the issue of the issues relating to whether or not it's been proven beyond reasonable doubt, or whether or not a court has adjudged you as guilty of that offense will not come in disciplinary proceedings under labor and employment relations.
Mr. Additional. I also want to thank our speakers for their invaluable insights, and the audience for also participating. We're almost at the end of this session, so I will be calling on our own Mr. Obafemi Agaba once again to give the closing remarks for this program. Thank you.
Thank you very much, Head David. And to the audience, thank you very much for being fantastic. I saw the number when we started, and as we are closing, the number has not significantly reduced. I think that's a testament to the fact that the session has been very interesting, and a lot of us have found it very useful. And if that's the kind of response we've received from the audience, then it becomes very, very important of me to say a big thank you to our speakers, starting with Honorable Justice I.J. Essien, PhD. My Lord started by schooling us, as a true teacher that he was before ascending the bench. I think, my Lord, we thank you so much for the time and your contributions. Mr. Taiwo Adeshino, I must say thank you to you, my dear partner, for not falling my hands, as they say. Thank you for your contributions and your wealth of experience in advising clients in this area of the law as reflected. And I believe that we can always come to you as we collaborate to give our clients pristine services. Thank you so much. Mr. Gbenga Bello, Deputy Director, Legal at IHS. I have known you from your days of practice, in the days of Shofunde, to the days of Akers, to the days of Austin Peters. When you put all those practice experience together, we could not have expected anything less than we saw today. And playing your role at IHS, I know that what we have learned today is a product of legal practice, both in and outside. Thank you so much for taking the time out and schooling us. Mrs. Ngozi Nzom, thank you so much for taking the time to contribute on these discussions. Your experience both in the private and public sector have come to bear with your submissions today, and we really, really appreciate your contributions. Mark Williams Uwogu, my dear senior associate, whom I must say has led the team in putting this webinar together. You have not just done well in putting the webinar together, you have also done well in smuggling yourself as a speaker on the webinar. I think you have no query because you have done well. Thank you very much for your efforts. Our dear moderator, Mr. David Kolawole, I was a bit skeptical when he was going to moderate. He's a young associate in the firm, but he has established himself as a master moderator, as a master speaker. Thank you so much, David. And to the immediate team that put it together, starting with Mark Williams himself, to Ed David, to Mayowa Durosimieti, and Taiwo Abiono, and other members of the dispute resolution team that has worked on this, I say thank you and well done. To the entire firm of Jackson, Etti Edu, thank you so much for your support. And to all my partners at Jackson, Etti Edu, thank you so much for giving us a platform to shine. And to the great audience, once again, I say thank you so much for heeding our call. And we'll be sending to you takeaways from this webinar and important things for us to note as part of the conversation that must continue even after this. Thank you so much, everyone. And I really, really, really express my gratitude. Thank you and have a good one.
Thank you, Mr. Agaba. Thank you for that brilliant closing remark. And on behalf of Jackson, Etti and Edu, I say we hope today has provided clarity and practical strategies for navigating issues around termination and dismissal lawfully. Please stay connected with us for more legal updates and industry-focused sessions. We'll be sending the recording via email shortly to the participants. Thank you so much for participating in this session. Have a wonderful day, everybody. Thank you.